Hello, everyone. This is Ellen Zimleys from Guidehouse. It is great to be here with you today. We are continuing in our series with Pillsbury, and where we actually get to talk about all different exciting things with a really good, panel of experts relating to anti-money laundering. Today, the topic, which is really, I think, a really good topic to discuss, is the proposed regulations and FinCEN's increased AML scrutiny relating to real estate. Now, for anybody here who's ever bought a house, you think that, is it really possible? Do people really do things that they're talking about? And in fact, I think in the last 5 years, the estimate is 23 billion in laundered money through real estate transactions. So, and that's what you know about. That's not even the things that they haven't been able to sort of figure out. So the answer is most likely yes, this is a big issue. People do launder money through real estate and in all different ways, in ways that people aren't usually used to seeing. So today we're going to have a discussion about it and how it works. We've got Alma Angadi from Guidehouse as well, my partner in non-financial crime, I guess, is she runs our financial services legislative and regulatory lead. She is the person who sort of keeps all of us up to speed on what's happening in the latest regulations and statutory changes. We also have from Pillsbury, we've got Aaron Hutman, who is a partner and helps engage large financial institutions and others, crypto firms, et cetera, in this space. Deb Thorne-Peden, who is with us all the time on these calls. Deb is basically in the practice that runs money laundering, banking, electronic commerce, privacy, et cetera, and OFAC. And then we have, as a special treat, I would say, or as our color commentary, we've got Andrew Weiner, who also with Pillsbury, but is is in real estate practice. And we've asked Andrew here to really talk about how this, as a practitioner, impacts the industry itself and what's going on. So with that, we're going to talk about, this is the agenda. We're going to talk about, give you just some background, timeline of some key developments, the history of AML oversight in real estate, FinCEN proposed rulemaking, statistics on all cash transactions. It's sort of fascinating to see this, a case study, gatekeeper regulations, which is a very big issue, and then how Russian sanctions and avoidance issues relating to sanctions might impact the real estate industry. So with that, let's just kick this off. Again, the real estate industry issues have been a big issue for a long time. In 2001, if we go back then, it actually went way earlier than that. But even in 2001, the EU began to include AML regulation for the real estate sector. And, the EU, things are there. They have much more, the gatekeepers are really held to a more regulated status than in the United States. And that was the first time they included it. Then in 2002, FinCEN exempted certain real estate closing entities from the BSA requirements because, if you are engaged in real estate transactions, you are deemed to be a financial institution under the BSA. We skipped to February 2015. There's a lot that went on in between, but it's for the purposes of efficiency here. The Times published something called the Towers of Secrecy, which talked about all the different real estate out there and how they're used by different entities to launder money. Oftentimes, they were foreign-owned. In 2016, FinCEN began issuing geographic targeting orders, GTOs, and they were actually quite effective in which they looked at those transactions in certain real estate transactions in certain jurisdictions and found that, that Miami, New York City, they went through several different GTOs and actually found that by focusing on this, you really did get a greater insight into what was happening and the illegal use of real estate transactions to launder money. In 2016, FATF identified vulnerabilities in the U.S. real estate sector. And then in 2019, there was guidance for a risk-based approach for legal professionals. Again, it impacts real estate, setting up LLCs, et cetera. And then we've got in December 2021, FinCEN issued the advance notice of proposed rulemaking relating to the real estate sector. And I'm going to even add to that because in May 2020, the National Strategy for Combating Terrorists and Other Illicit Financing came out, which again referred to that they've had real estate issues in this document for several years and reiterated the issues. And that's just this past month.
Can I just add one quick thing?
Sure.
This is the timeline for traditional real estate AML. And everyone in the audience, I don't know the degree of familiarity people in the audience have with the whole universe of this, but this is now becoming only a major part, but a part of a much larger constellation of complementary legislation and regulatory developments, which are to some extent duplicative, to some extent contradictory of what's going on. But people who are in the real estate industry have to know all of them, like the Corporate Transparency Act, which we'll talk about, statutes like the Enablers Act, which is roaming through Congress, perhaps on its way to passage. There are state and local enactments of a similar nature, particularly, I know New York City and New York State both have them. And so we're all going to have to know things beyond this and try and weigh how one thing reflects the other.
Thanks, Andrew. So let's go to the next slide. And we'll talk about the history of AML oversight on the next slide. So, Alma?
Sure. So as Ellen said, the Bank Secrecy Act, which was amended by the USA Patriot Act after 2001, defined persons, as Ellen said, involved in real estate closing and settlements as financial institutions. These were exempted in 2002 for the very simple reason that there are lots and lots of real estate transactions, and so many of them are not indicative of crime. And so many of them do not include the proceeds of corruption as an investment. And I think the Treasury Department and FinCEN correctly thought we can't just make all title insurance companies, at this point in time anyway, subject to the very complicated regulatory scheme that banks and broker-dealers and money transmitters are. So they exempted the real estate industry from that, as Ellen said, getting some criticism from the international bodies that manage money laundering compliance in the meantime. But what they chose to do instead is issue geographic targeting orders that cover real estate. Now, geographic targeting orders are a way that the Treasury Department, just as the name suggests, can hone in on what they think is a problem, a money laundering problem, what might be a money laundering problem, and issue temporary reporting and record keeping requirements so they can gather information about that segment of the economy or to disrupt criminal enterprises. For example, a couple of years ago, they issued a geographic targeting order to the Los Angeles Fashion District, which had been found to be laundering drug cash through cash transactions at different manufacturing facilities, and to what caused that to kind of disrupt that method of money laundering. But for geographic targeting orders, they started and have continued to expand to gather information that leads to, I think, the proposal that folks will talk about today, where they're really going to expand it. So,
and Emma, those targeting orders actually proved to be helpful. That you know, they start out as a test, as a pilot, right? And then after that, they actually felt like, wow, these are actually working. That this is we're getting more information from this. We're actually seeing transactions that are used to launder money.
Well, and I just want to mention that obviously for the banks have had extensive requirements in terms of filing suspicious activity reports, tracking for unusual activity throughout the last number of decades. So although some of this is new for real estate closings, in terms of financial institutions that are licensed and subject to the BSA, by and large, they've been filing, SARS collecting information on companies for decades, literally, because they've been required to do so. So I just want to also note that by way of some of the background.
Although that has changed.
On a real world basis, one of the things you have to understand when you go here, it's very easy to go and say we're stopping money laundering because ownership of real property can be secret. And I know there's a lot of money laundering, and I am supportive of activity to stop that. But there's also an awful lot of real estate where the people buying real estate don't want their identities known, which is not illegal, has no illegal intent. And the disclosure of the identities of those people could be very damaging in ways that have nothing to do with the legitimate prosecution of legal outcomes. And that's part of what has to be balanced in all of what's going on here.
From that regard, Andrew, it's important to remember this isn't publicly disclosed, right? Like, let's go to the next slide, and we'll talk a little bit about what the GTO requires. And remember, these are time limited. So this is the 11th renewal, and it requires title insurance companies in certain cities that law enforcement suspected had a lot of illegal real estate transactions, purchase a residential threshold of $300,000 without a bank loan or similar external financing, and purchased in part using currency, funds transfers, money orders, that sort of thing. And this information goes to the Treasury Department, which law enforcement can access. So the information about the beneficial ownership is disclosed, but not publicly. So I think that's the balance you're talking about, and or at least that's a balance they're trying to achieve, because I don't think they would necessarily disagree with you.
So Alma, in addition to that,
I agree with that, and for targeting orders so far, that's been fine. In other things that are being proposed, confidentiality, even if it's agreed upon in the statute, can't be guaranteed, among other, you can talk about hacks, but the mere collection of information by the title company or under the Corporate Transparency Act by the reporting company is not protected by statute as confidential or immune from process. So the rules about what really is confidential in the real world for everything that's now being proposed or has been enacted in addition to the targeting orders is really not clear.
Yeah, so even if so it may be that from a financial institution's point of view, there may be an LLC that is there, and the institution must know that who the beneficial owners are of the LLC, but that is not necessarily what gets reported publicly. But to your point, Andrew, I guess we don't know yet. What is interesting is how the banks have over time developed, because it used to be that although they've had those suspicious activity reporting requirements for a long time, if you had a jumbo mortgage or a really large mortgage, the bank actually did less CDD or less investigation into that because it was secured by a property. And that property, they knew that if there was a default from a credit perspective, and then if they were looking at it from a credit perspective, they said, well, we have a big property, but not worried so much about the source of income for the borrowers because we know that we're protected that way. That has changed over the years as they've had to do more and more. But that was originally, years ago, that was the model that was followed. Now they're all, they have that same requirements of knowing your customer, whether it is a mortgage or any other sort of transaction that's done, any other account. But the world has moved in this way, and I think the banks have, and the real estate industry is going to have to move in this world as well. All right, why don't we go to the next page? Alma, you wanted to continue on this?
Yeah, it's just a little bit more detail about what's required, what the real estate title insurance companies were required to file, basically report saying this happened with the amount, and they have to identify the representatives, the entities, and the beneficial owners to 25%. And Deb, I think you've made this point before, and this can be difficult. Attorney-client privilege doesn't apply to sharing client information with the title insurance company, and there's a 5-year record retention policy.
But what happens in the real world when you go to a closing is the title company has usually no idea who they're dealing with, when there aren't real individuals sitting in front of them. So when you have an LLC, they would not necessarily know, and they're relying typically on affidavits prepared for them by the party itself. There's not much diligence that is being done or really can be done beyond that. So it's almost a self-description process.
But they can still file on it. They can certainly still do screening on it if they wish to for OFAC purposes. There are other things they can do with it, with the information that they've.
Right.
Going back in history for BSA, when some of the laws were put into place, I will say the exact same arguments were raised in terms of even for some of the banking KYC pieces of we want to have our privacy. Some people were claiming that if their privacy was violated and they had to provide information on who they were, could put them in danger. So those arguments, have been certainly considered as part of the regulatory structure and in terms of who has access to the information and who does not. So I just want to note that for you as well.
Okay, I think we can go to the next slide. And Aaron?
Yes, hi everybody. So we've been doing a wonderful tour of the regulatory side of the anti-money laundering universe. And many people in the audience are at financial institutions or are in real estate sector companies that they're worried might become a financial institution as a result of this rulemaking. But of course, anti-money laundering rules exist in criminal and civil statutory form and can apply to all of us. And you don't have to be a gatekeeper. And so from the perspective of the US government, there is enforcement in the anti-money laundering sphere that is much broader than the regulatory regime under the Bank Secrecy Act as it's been amended various times. And so we wanted to talk a little bit about that for context before jumping further into the advance notice and all the exciting rules coming down the pipe. So if you were in the real estate field, or frankly in a lot of different fields, and you were thinking about what is legal or illegal in the United States or doing business through US interstate or foreign commerce, there is actually a criminal anti-money laundering statute or two under the Money Laundering Control Act, 18 USC 1956 and 1957, which prohibit a variety of transactions where the funds involved or property involved with this transaction come from, with knowledge, some unlawful activity. So you're involved, you have some inkling that there's something nefarious going on or something illegal involved, but you don't know what. And in fact, there are specific predicate offenses that related to this criminal, related to the funds in the transaction. And if you were part of that transaction or you deposit that money in a bank, you can be in violation either criminally or civilly of US criminal anti-money laundering rules. And so this is what we think of as the anti-money laundering sanction. Predicate offenses include tax violations and fraud and stealing of property, corruption, sanctions violations. There's a lot that goes into the underlying predicate offenses. And these aren't the only rules that are used to prosecute money laundering. There are bank fraud statutes, wire fraud statutes, mail fraud statutes, the Travel Act, RICO, things that if you've watched CSI or any of these real crime shows, you've probably heard these terms. And these are real statutes, and they can be used to prosecute money laundering, and they are used frequently in the real estate sector. In addition, you've probably heard a great deal about sanctions recently because of the invasion of Russia and because words like SDNs and specially designated nationals or blocked property are becoming more part of our national lexicon. And sanctions are very much wrapped up in any money laundering enforcement and in the real estate game, particularly where sanctioned parties are trying to hide money in the US real estate sector. And so these statutes would be along the lines of the International Emergency Economic Powers Act or specialty statutes relating to sanctions regimes, like CATSA or the Ukraine Freedom Support Act or the Iran Threat Reduction Act. And you'll hear more and more of these coming through Congress. I wanted to provide just two examples to give you context for how this matters in the real estate field. So Paul Manafort, you guys might remember that name. He was the campaign manager for Donald Trump in his first run for president and had a history in Washington, D.C. as a wheeler dealer. Well, before being the head of the Trump campaign, Manafort had been involved in providing guidance to the Ukrainian government when it was a Russian puppet government. And Manafort had wanted to get that money back into the United States, and he used indirectly in one of the ways the real estate sector. And so there were a lot of schemes that were alleged and related to Manafort, but one of the most interesting ones, to give you a taste of how real estate can play a role, Manafort had made a great deal of money consulting for Putin and Russia-supported groups in the Ukraine, put that money into foreign bank accounts, and then to get that money into the United States, used it to buy real estate in cash transactions and interact with normal and reputable U.S. banks, then mortgage out the money from those properties. So the money is then in the United States, can be used in U.S. commerce, and Manafort wasn't paying taxes on these. So you had elements of bank fraud, representing a foreign government without talking about it, not declaring your foreign bank accounts, not paying taxes, and all of these were predicate offenses that supported criminal anti-money laundering violations, as well as separate bank fraud and FARA fraud and other issues. And so a good example of how real estate can be used by famous people and also people you've never heard of to move money around illicitly. Another is, many of you might remember hearing about the Iranian government having skyscrapers in New York City. And so between 2008 and 2014, we had a finding that the Iranian government had real estate in New York and in several other states. A good example of where the banks and other parties involved might not have realized exactly how much the Iranian government was involved in related to prosecutions. A good example of how sanctions can be involved. So real estate sector, a lot of different rules involved, and I'll kick it back over for the next slide.
Thanks, Aaron. We got a couple of questions that I think it'll be a quick answer to folks before we move on. And thank you for your questions. We love to get them. One asked if you could evade these requirements by choosing a title company in a different location from the property, a title company in an area not covered by the GTO. But the GTO covers the property for sale. So it doesn't matter where the title company is. But that's a really good question. And that's exactly why they drafted it that way, so you couldn't do that. The other question is, do you lose attorney-client privilege if you share privileged information with the title company? I think the issue there is more the information that you are providing the title company about who's purchasing the property is not considered privileged. It's a business transaction, not legal advice. And Deb, you may have some more to add about that, because we talked about it a little bit before, because it's another really good question.
Yeah, and we'll talk about it a little bit more, but Alma, you're right. And one of the things that attorneys have to consider is, are they giving legal advice, or are they basically just working on the business? And one certainly has more protections under the attorney-client privilege than the other, but we'll talk about that a little bit more. Okay. So in terms of so actually, go back one. Thank you. So FinCEN, which for those of you who don't know, FinCEN is part of the Department of the Treasury, which is an agency that's basically empowered to impose regulations related to the Bank Secrecy Act under the various federal laws that have been passed by Congress, et cetera. And FinCEN's been around for, I want to say, 25 years now, so a very long time for those of us who work with them. And it stands for financial, actually, I don't remember what FinCEN stands for anymore. It's been so long. But basically, it's financial transactions. As I said, FinCEN really just is the regulator for a lot of the BSA. And
Financial Crimes Enforcement Network.
Yes.
Thank you. I figured you'd know that one.
I won't interrupt. Yes.
Yeah, and I should know it normally. It's still early here for me, but anyway. Yeah. So FinCEN a couple months back basically came out, through a publication through the Federal Register, if I recall correctly, it basically saying that they are looking at expanding the Bank Secrecy Act to a broader range of real estate transactions and entities. And part of their rationale for that is because of some of the statistics that they've seen in terms of transactions involving potential money laundering, possible terrorist activity, transactions involving what's known as a PEP, which is a person, generally speaking, who has a relationship to somebody very powerful in other countries, et cetera. PEPs include family members, et cetera. You had the Panama Papers that came out and obviously exposed a number of transactions that were questionable. I do note that other countries like the UK are already in front of the US in terms of imposing some of the Bank Secrecy Act obligations on real estate companies, et cetera. But it was about a 58-page document when you printed it out. A lot of it was FinCEN asking questions because they wanted input in terms of, we're looking at possibly expanding this in a couple of ways. One option would be to remove the exemption that FinCEN granted back in, I think it was early 2000s under the Patriot Act, and instead now apply the general Bank Secrecy Act requirements, and especially the CDD rule, which is the one that requires information on beneficial owners, to anything that's covered as a real estate entity under the definition that is in effect at the point in time they trigger this. So that's one approach. Another option, of course, when you look at GTOs, which is what we've been talking about a bit thus far, is to not limit it to just certain geographical areas and possibly expand it across the country. And FinCEN has, in that document, also spent a lot of time actually also considering expanding this into commercial real estate as well as just residential. So this would be potentially much broader beyond just residential properties. It would be commercial as well. FinCEN's considering or asked a number of questions about whether or not, if it goes that route, should it do it in two tranches, maybe expanding it first in the residential area first, and then do the second tranche in terms of commercial. FinCEN will ultimately come out with additional proposed rulemaking in terms of, based upon the information that it got, and it even extended the time frame to get comments. But FinCEN will ultimately come out with a proposed rule in terms of, here's what we're looking at expanding, here's how it would look if it's our final rule. They will have gone through the comments in conjunction with that. And I think that there will be another option possibly to give additional information at that point in time. But then FinCEN will, at some point, it will issue a final rule, which says, here's our rationale for the decisions that we've made. Here are the laws that are going to be part of the Bank Secrecy Act, and it becomes federal law at that point. They usually give a period of time in order to ramp up to be able to comply with those laws and regulations that they're putting in place. That's in contrast, by the way, to the Office of Foreign Asset Control economic sanctions that Aaron was mentioning, because those become immediately effective upon publication. So with the FinCEN ultimate final rule that will come out on this, there will be time frames in which, for companies to be able to come into compliance. That would be standard. Anything you want to add on that?
Yeah, but Deb, it's hard to read the document and not come to the conclusion that FinCEN's signaling where it wants to go. I mean, do you have a sense for where you think it wants to go when it finally adopts something?
My sense, and certainly interested to hear everybody else's view on the panel as well, is I think that they will certainly be expanding it. There's no question. I think they're going to expand it to cover commercial properties. Again, they may do it in a second tranche aspect rather than just first and not keep it to residential. I think that they feel that there's a lot of illegal activity going on in the real estate market. And I'm not saying people are bad. It's just, inherent with almost any sort of business, there's going to be some money laundering. It's pretty hard to keep it out of it. I think they've gotten, I think FATF has sort of looked at the U.S. Where we're at on real estate. And I think probably FinCEN's gotten some feedback on that. And like I said, other countries are arguably in front of us on this. So, I think that I think that what they will probably ultimately come out with is they will expand it without a question. I think FinCEN, like usual, will also have certain types of entities that will be excluded by definition from what's covered. So by way of example, Andrew, in a lot of the Bank Secrecy Act regulations that have come into play, publicly traded entities are often exempted just because they've got so much oversight anyway. FinCEN has excluded them. Sometimes they will exclude transactions under certain dollar amounts, and they will probably have some dollar thresholds possibly where they will exclude it because the dollar amounts are so small that they may not view that to be something of importance. But yes, I do think this is coming, which is the reason we're having the webinar today, is to get people, being aware that this is likely coming. We don't know the exact time frame. I would guess, and Alma and Ellen, I'd be curious for your thoughts. My guess would be probably sometime later this year, just given, FinCEN's focus on it, although FinCEN's awfully busy right now, I know, with the sanctions as well. I don't know. Do you have any sense of timing?
I think year end is possible. I think they are very, there aren't that many people at FinCEN, right? And under the Anti-Money Laundering Act of 2020, they have so many regulations and so many things that they're supposed to be addressing, creating a utility for, for CDD purposes. There's a lot of work they've got going. And so it may just be that they don't get to it, or that they just can't, they just don't have enough people to address it. But I don't see, when you think about what they've found so far and what's out there, it doesn't seem like there's any reason not for them to expand it for that purpose, unless, the commercial real estate PACs have a lot of power and can make, can basically explain why there are ways or things that should be excluded, excluding more than maybe they thought before. But I don't see a reason for them to say they shouldn't be included. I agree with you. It's more of a question of enforcement of it. How are they do they have enough people and enough ways to enforce this and to take in the data that they might get from this? This is always the issue with SARs being filed. All these SARs get filed and nobody looks at, and there's a belief anyway that people aren't looking at those SARs. And this is the same kind of question. If they get all this, who's going to then examine this? But I don't think that there's been any statement, I haven't seen anything yet anyway, that says this is not a reasonable action to take in terms, if your goal is to find more money laundering and to prevent money laundering, if that's your goal, there doesn't seem to be a reason not to do this, not to expand it.
But what the MPRIM doesn't do is really show two areas. One is, who do they think will be required to report, which is your point about enforcement. And the other is, what kind of entities, if they acquire an interest in real property, what kind of entities are those whose transactions have to be reported? And one of the questions that follows on that is, FinCEN is at this moment doing regulations, basically, at least in the latter case, creating regulations defining whose transactions should be reported. Do you think there's going to be some coordination of those definitions, or are we going to have different statutory regimes with different definitions of the same concept?
I mean, there are working groups that talk about it, but as you know, even the different entities have different missions and different interests in sometimes in getting things done. So I think that they're all different organizations and all different working groups. There's, the Bank Secrecy Act advisory group. There are different organizations that have a piece of this, but will it be perfect? It will certainly not be. That's probably what you can bet on, that this is going to have, that there will be things to work out afterwards and there will be imperfection here. But, I think the issue of whether it's going to happen is probably yes. It's going to, I feel the same way as Deb, that this is likely to happen. And then it's always going to be, how do they, as I said before, how do you get to enforce this, and what's the burden going to be? They do have to show what the burden will be and to have to address that. And is there an inappropriate burden being placed? But otherwise, I think it's.
And Andrew, while it's no guarantee that it will help, there is a provision of the Corporate Transparency Act, which is the statute that will require certain entities to register their beneficial ownership with FinCEN, that says they are supposed to realign the customer due diligence rule that's currently in effect to avoid some of those conflicts that you're talking about. Now, again, whether that will happen and what the timeline will be is anyone's guess. Because in that one, they have to build a whole database. So who knows how long that's going to take. So I think you're absolutely right. There is a lot of conflict between some of these regimes, and hopefully they'll at least try to minimize those.
And many of those timelines from the Anti-Money Laundering Act of 2020 have passed.
Right.
Without the action
happening.
Yeah, they're almost they're pushing on 6 months delayed in getting the regulations adopted.
Yeah.
And they're nowhere near.
Right.
Right. Okay, we've got a lot to still cover. So
yes. Next
slide.
So this is what Andrew was talking about, right?
Right, in terms of who may be covered. So under the CDD rule, as we mentioned, FinCEN did request comment on expanding the definition. And, it's an interesting list of what they're looking at expanding it into. As you note, the first one is real estate lawyers and law firms. And there certainly is some lively discussion around that. Can you take it back a slide, please? Insurance companies may be covered. Title companies may have expanded obligations. REITs may get pulled into this. Developers, property managers, auction houses, investment advisors, private money lenders, money services businesses in terms of the reporting aspects. But it can certainly go beyond, in terms of what FinCEN puts into place for real estate, it can certainly go beyond this list as well.
And in Congress, there's the Enablers Act, which would add accountants, trust advisors, and public relations people, so that they're competing regimes to make it coextensive with the universe.
Okay.
Right. And lawyers are already covered in the UK and in other jurisdictions. So that one of the things we were discussing actually before this event is there an issue if you have a property, or an issue, transaction that involves U.S. and the UK or lawyers in various different jurisdictions? Does it even matter if the U.S. doesn't require U.S. lawyers to file certain information or to report certain information if they are required to do in the UK and there are UK lawyers involved? So there will be, I think there is going to be sort of jurisdictional arbitrage a bit probably going on, but the issue on the legal fee will be, I think, royally battled here. As it always is, right? It always is.
Yes,
it's
it always
forever,
is.
Right? And so, but the issue is if you've got a large transaction that involves different jurisdictions, it may not be as meaningful that the lawyers in the U.S. don't have
Right.
to do this.
Yeah. One word that is not in this list, which will be a sort of a marker for what we're going to talk about later, is trustees.
Mm-hmm.
Because as these statutes develop, the big hole is how do you deal with private trusts?
Right.
And no one's come up with a solution for that.
Not yet.
Mm-hmm.
Not yet.
Okay, next slide.
Okay, so we've talked a good bit about the geographic targeting orders, and I'll help keep us moving here. But generally, one of the ideas is that we've had a fairly specific targeted regime where FinCEN has said, in this city, in this county, for real estate up to this value, if you're a title company, you have to engage in certain record keeping, data collection, and reporting. Now the NPRM is asking, well, should we be looking at a broader scope? Should we be looking at reporting, record keeping rules that would go nationwide? Should it be limited to title companies, or should we be looking at other people in the real estate ecosystem? So we just went through a long list. And I think for the real estate community, the lesson to come out of this is that there may be a much broader scope of what we now think of as narrow, just here and there geographical targeting orders that focus on non-finance transactions. So as the rules develop, look at how this might expand and how you might have more responsibility on different people in the ecosystem and more responsibility to report.
Great, next.
Okay, this slide covers an area where there's a lot of dueling definitions among various proposals. There's sort of for purposes of money laundering, for purposes of the Corporate Transparency Act, there's a definition evolving, or exists at least for the money laundering, but corporations, limited liability companies, limited partnerships maybe not general partnerships. I know the CTA is moving in a direction that if you file with a Secretary of State or some office like that, you're covered. If you don't, you're not. So general partnerships might not be, and many private trusts, testamentary trusts, inter vivos trusts, would not be, and that's very painful to FinCEN. And you can almost feel the plaintiveness of their concern in the end print when they beg people to come and comment that they should be covered, to give them cover. But for the money laundering people, what is the exact definition now under the AML regime for what entities are covered?
Well, it depends on what you mean by covered, Andrew, because the entities that have to have an AML program and report are banks, broker-dealers, futures commission merchants, money transmitters, insurance company, mutual funds, right? The financial institutions. And the proposed rule would bring certain real estate gatekeepers into that. Now, who's covered is anybody who opens an account or does a transaction with those entities is subject to varying degrees of customer identification and due diligence, depending on the entity and the amount.
Right. So if you're the customer versus if you're the client, you've got to, generally the financial institution, whoever that is and whoever that's named, needs to find flesh and blood somewhere and needs to sort of get to a person and do that. So, but all this is about, I don't want to make this more than it is in a way, because one is being registered or being, where someone has to know who you are. That doesn't mean that that's illegal. LLCs aren't illegal. LLCs are a totally legal, vehicle to use, as are partnerships and other business entities. It's just a question of knowing who's behind them so that the financial institution, and I use that broadly because now that includes the real estate industry, just needs to know who they're dealing with. And so it doesn't make these organizations illegal. It just is saying we need to understand who's really behind them.
And they may certainly differentiate even between real estate companies and what exactly they have to do. As Ellen and Alma mentioned, for many under the Bank Secrecy Act, you've got a full-blown obligation to have a full-on anti-money laundering program. You've got to have internal controls. You've got to have policies and procedures. You need to have a knowledgeable Bank Secrecy Act expert as a head of compliance. Boards need to be behind it. You've got to file certain reports and do certain record keeping as well. So some of it they also might do lesser obligations or lesser reporting for certain sorts of real estate entities as well. But that's part of what they'll be working through.
I think the issue is also is who's going to examine them. Right, because you're not going to have a bank regulator examining them. This is the issue that comes up all the time with money transmitters and others who have a requirement to have this, but sometimes it's maybe a state agency that does that, but that can be done inconsistently. And there are a lot of other issues that will come when you have all of these entities that will now need to have a program. How are those programs going to be actually reviewed?
Although for money services businesses, which, by the way, for those of you who don't know, include a variety of different sorts of like money transmitters, exchangers of currency, et cetera, check cashers, they're actually examined by the IRS currently, not in a tax capacity, but in terms of compliance with the Bank Secrecy Act. I know there's been some conversations in terms of whether or not that would continue to be the case. But just given that that's sort of the current structure in terms of who has oversight. And Ellen, I'm also thinking about, when they expanded the laws to include jewelers under certain circumstances, and they're in the process of expanding them to cover certain antiquities. Historically, they've used IRS in that limited capacity if it's outside of a normal regulatory structure. But it'll be interesting to see what they do with that.
Yeah, but the IRS is pretty stretched.
Yeah, I was just going to say, Ellen, they didn't examine any insurance companies last year. No.
Right. Yeah. And so they have been given the authority to. Whether they actually do it and how much they can actually do is a different story. And so that's why the IRS has plenty to do on its own just to deal with, with tax issues and other, IRS requirements, so that it put a burden on the IRS that I don't think that it could really handle. And that would just make this even exponentially more. All right, so
and you end up with a system that's enforced by enforcement, right, rather than regulatory oversight.
Correct.
Companies have to avoid the risk of a criminal prosecution or civil action coming later. Put the effort in, but you're right that they're not going to get that day-to-day guidance or oversight or annual review. They won't know that things are wrong potentially until things are very, very wrong.
Correct.
That's a good way to put it, Aaron.
Yep.
All right, so we have like 13 minutes.
Next slide.
So I just want to keep going. Yep.
Yeah.
This is a good one, Alma. The next one. I like.
Yeah, the next one, Kristen, please. This is just to give you a sense of really what we're talking about. This is not that in 2021, 61% of all cash purchases were by non-U.S. residents, 24% by U.S. residents. And you can see that number's gone down since we started having geographic targeting orders. And the slide on the right shows the same breakdown in commercial real estate. So there is a lot of money happening. Again, it's not all, these aren't all Vladimir Putin residences and other corrupt officials, but it's a lot of transactions. And so FinCEN wants to make sure somebody is looking to look out for the bad ones. So.
And merely because you're a foreign entity who's buying real estate in the U.S. doesn't mean it's illegal either. It's just that is, that's it's been a use by foreign entities. Okay, next, the case study.
Okay. Again, we're going to move a little bit outside of the regulatory gatekeeper realm, but still in an area where you see where the banking system functions and the real estate system is a store of value and used for part of money laundering schemes. So this is just one of many examples that are out there. And a recent example in 2021, the general manager and a project manager for a seed company that was based in Washington State but had been purchased by a Chinese parent had been involved in a scheme. So this wasn't the company bribing foreign officials. This was more internal folks engaging in embezzlement and schemes to defraud. And so and Christopher Claypool pled guilty. Other parties are still under indictment and pending. So usual caveat about allegations and innocent until proven guilty, but moving on from there, we have a situation where in a seed company setting, the executives had put together elaborate frauds claiming where there were kickbacks and rebates that were put on the books. Money was funneled offshore. There were a couple of other schemes that were involved, but money was funneled offshore to Hong Kong financial institutions. The money was then moved to make cash purchases of real estate in Hawaii, a highly liquid and popular real estate market. Land was developed. The fraudsters involved made a lot of money out of it. And the banks that were ultimately involved really weren't aware of the underlying fraud. And this goes to both the challenges of current systems, the challenges of financial institutions and real estate transactions that cross borders and are in multiple jurisdictions. And then the unusual types of underlying fraud. And when we talked about criminal anti-money laundering statutes, that there are a variety of predicate offenses that can serve as the basis for these rules. We can move to the next slide for the red flags. So here, red flags for people who are involved as investors or participants in a real estate transaction, red flags for potential new financial institutions and that long list that we saw in the real estate field, and red flags for traditional financial institutions like banks and fintechs and credit card companies and so forth. There's some ones that we're all familiar with. If there are unclear relationships between the parties, if companies are doing things that really seem way outside of their purview, if people suddenly have a lot of money and it's not clear where that, those funds came from, these can all be red flags for underlying money laundering transactions. And you can use LLCs or companies as fronts. Sometimes individuals can act as fronts for third parties. And these can be hard to figure out. And that's why it's important to have gatekeepers in these systems that are collecting due diligence, looking for ultimate beneficial owners, detecting red flags, and making reporting so that national law enforcement can put all of the strings together. And so I think that with the new rules that we have on the gatekeeper side, you're going to have more participants in the ecosystem, however these rules shake out. We're going to gather more information, and under laws like the Corporate Transparency Act, potentially put some of that money into central databases so we have more sense of beneficial owners. We'll see how all this shakes out, but the red flags are important for everybody involved in these real estate transactions.
Going to gatekeeper regulations and lawyers, you can say a lot about this. This could be its own presentation, but the legal profession has been opposing this kind of disclosure, at least as it relates to them, since the World Trade Center went down. And they have been one of the primary forces why the real estate transactions, which the legal profession is knee deep in, have been exempted, and why the legal profession itself has not been regulated. There are some problems that really do exist that have to be solved before you can work this out. One of them is the duty of confidentiality that lawyers have. The other is the attorney-client privilege, which is a core of not only the legal system, but the way business is conducted in the United States. And the last is just the burden on law firms, although law firms can't really argue the burden is worse on them than on accountants or other people who are targets at the moment. The problem that lawyers are going to face, however this comes out, is getting caught between their clients and the law in this one. And you really need to see the final regulations to see how bad the problem is. But even if you look at clients being asked to render practical advice to fund sponsors as to how they report for themselves, assuming they're not exempt, how they report for themselves and their investors, how you document transactions so that sponsors have an obligation to do what they have to do and investors have an obligation to do what they have to do. All of that is going to take an awful lot of working through, which we don't have time to really explore, but people should be preparing for that now.
Okay, so we have about 5 minutes left, so I just want to make sure.
So can we go on to the next slide quickly,
Yeah.
Ellen? I just want to touch on that one.
That. And we have one question that came up as well.
Okay, so if we can go back a slide, that'd be great. So one thing to keep in mind in terms of the attorney-client privilege and the obligations of attorneys to keep information confidential is it is a more complex issue because obviously there's underlying constitutional rights that run, even whether or not you've got a client who's potentially engaged in that illegal activity. If the attorney is having to provide information to law enforcement about it, that's completely undermined their ability to claim the fifth as it was. There's issues in terms of whether or not you're sort of getting into possible Fourth Amendment of the Constitution issues in terms of, whether that's illegal for that information to be provided. For attorneys, it would put them in a particularly hard position in terms of if they've got somebody that they know is doing something illegal, generally speaking, they're supposed to not work with that company and they should not continue to support them. But that is a far different thing than having an affirmative obligation to report. For in-house counsel, I think it's going to be particularly hard just because I think and I've been in-house for a lot of my practicing life because a lot of times you're clearly doing just legal work and providing legal advice. There's no question about it. And I think if there was an exception, for that, they would clearly be covered. But I think sometimes when you're in-house, depending upon what you're working on, you might be doing it more as a business piece rather than as legal. And I think that that's going to be a harder thing for attorneys to the extent that they are covered to work their way through to figure out whether or not, are they just practicing legal advice, which might have an exemption, or are they actually just doing business and therefore there wouldn't be an exemption. And I do think that that's going to be one of the hardest things to unpack as the regulations come down. And then, Ellen, I know you mentioned do some
We've
questions.
got 3 minutes left. So we did have another question here about the impact of proposed regulations on the EB-5 program. I don't know if anyone feels that they can answer that issue. And the EB-5 program has to do with foreign individuals getting a visa in the U.S. if they make a certain investment. So I don't know if anyone wants to take that one.
Well, first of all, you have to determine whether the EB-5 investors meet the. You don't do any of this in terms of the aggregate of foreign investors. An individual reported on person or entity has to own a certain percentage of the deal. And many of the EB-5 deals are widely enough syndicated so that people would not have to be reported under any circumstance. But there's no exemption in an EB-5 transaction. I mean, the other thing is a lot of EB-5 comes in as debt. And if it did mezzanine debt, for example, and until there is a foreclosure, you wouldn't have to report it under normal lending principles. So it really depends, but it could be covered. You just have to look at the facts of each transaction.
All right. So I guess we can sort of end this on this issue. And I don't know if, Aaron, if you wanted to talk about this is the issue of sanctions. And there's a Washington Post article here. You see the headline. Aaron, did you want to address this?
Absolutely. You guys might have heard that there is a dispute going on in Ukraine right now. It is shaking the world. The 11th largest economy, one of the major oil and gas producing countries, is literally being moved out of its role in the global economy in a number of ways. And that is impacting a number of the wealthy Russians who have been investing not only in the United States, but other countries around the world over time. And U.S. sanctions are targeting individuals, they're targeting companies. There are a variety of rules related to imports, exports, the oil sector, and services provided, which I guess can include management services in the real estate sector. So sanctions continues to be a big issue. And just as I started earlier with the stories about Iran, I think that U.S. law enforcement, there's a klepto capture initiative looking at corruptly or unlawfully derived Russian assets. And I think that there's going to be a really hard look by the U.S. government, Department of Justice, that has a well-stocked task force that will be looking at real estate deals around the United States. And I think that that's going to put pressure on some of the developers and sellers of some high-value real estate where there might have been offshore investors in numbered or LLC companies to think harder again about who is investing in their projects, who is in funds, who is the owner behind some of these condos. And there can be very real legal ramifications if there are sanctioned parties involved, and particularly if a person knew and kept on going, that U.S. persons have blocking obligations for dealing with sanctioned parties, and can also be in the position of defrauding banks.
Aaron, we're going to cut it off here. We want to thank everybody for their involvement and for participating in this with us. And we're going to just want everyone to know that we will have this on the website. The slides will be on the website. And I think that the taping of this, you'll be able to get a video of this if you want on the website too. So I want to thank our colleague, our friends from Pillsbury. Thank you for being involved in this with us. We appreciate it. We love doing these with you. And we'll be in touch soon.
Thanks very much.
Bye, everybody.
Thanks, everybody.
Bye.